Hi there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, and today I want to talk to you about disability panels when it comes to an estate plan, what they are and why you may want them included in your trust. Now, when you create an estate plan, it's an admission of your mortality. But even if you accept that you're not going to live forever, you may be slower to face the possibility that you could become incapacitated before you actually pass away. And although this can be an uncomfortable topic, incapacity is an essential but often overlooked part of drafting revocable living trusts. Placing your money and your property in a trust can accomplish many estate planning objectives, including planning for your incapacity. Now, should you suffer a disability, your mental competency could come into question. And then at that point, it will need to be determined if a backup trustee should take over the management of your living trust. Who exactly makes this key determination is extremely important. Naming a disability panel in your trust allows you to exert control over your incapacity plan by choosing a group of people that you trust to determine if you are incapacitated. Today, Americans can expect to live longer than previous generations. And living longer doesn't always mean living better, though, as most of us are aware. Now, older Americans are much more likely than younger Americans to have a disability, according to research. About 1/4 of Americans and roughly half of Americans over the age of 75 report living with a disability. For 18 to 34-year-olds, that number is just 6%. And around 13% of 35 to 64-year-olds say that they also have a disability. Now, disability can affect anyone at any age. However, the longer that we live, the more likely you are to suffer from a disability. In certain disabling conditions, such as Alzheimer's, that are age-related. Currently, more than 6 million Americans are living with an Alzheimer's diagnosis. By 2050, the number of Alzheimer's patients is projected to more than double, all the way up to 13 million. Now, roughly 1/3 of seniors die with Alzheimer's or another form of dementia. A living trust, also known as a revocable trust, is a popular estate planning tool that allows people to avoid probate, eliminate, defer, or lower estate taxes, and distribute in money and property to their beneficiaries at their death. Now, another major benefit of a living trust is that they help the trust maker, also called the grantor, the trustor, or the settlor, arrange for the management of the trust money and property should they themselves become disabled or ill, or the victim of an age-related diagnosis, which results into a decline. The trust maker is typically also the trustee of their living trust and handles any administration that may be required, such as recording trust income and expenses and filing tax returns. Now, there may be a co-trustee, for example, a spouse, who shares these duties. If there's no co-trustee who can continue to manage the property held by the trust, then a successor trustee, named in accordance with the trust document, should take over as trustee when the trust maker dies or becomes incapacitated. Now, it is possible for the trust maker to name 2 different individuals to serve as the successor incapacity trustee upon the trust maker's incapacity and successor death trustees upon the trust maker's death. Now, within a living trust, a trust maker can define when they are deemed to be incapacitated. So there's no doubts about when a trusteeship passes from the trust maker as trustee to the remaining co-trustee or successor trustee. For example, the trust maker could include a general definition in their trust stating that incapacity begins when they're no longer able to manage their financial affairs, or they could rely on a more objective measure. In addition to defining incapacity, the trust maker can choose a group of people to determine if the definition has been met. The trust documents can leave this decision to a doctor or the court, or the trust maker can instead name a private disability panel. Now, a disability panel is just a group of pre-selected people who determine if the trust maker is incapacitated. The trust maker selects these people ahead of time and names them in the trust. The trust should also state whether the panel's decision must be made by a unanimous or a majority vote. Now, a physician or a court, while ostensibly qualified to weigh in on disability, may not be best suited for that task. The trust maker may prefer to name a disability panel because it can include the people that you know or who know the trust maker best and can recognize when something is going wrong. They may feel more secure with a bunch of people from varying backgrounds, such as medical professionals and trusted family members, making the determination. And it eliminates the need to pay an attorney to go to court to have the trust maker declared incompetent. And it circumvents red tape and avoids delay that can affect estate planning considerations. Now, creating an estate plan is all about taking control of the future. Naming a disability panel gives the trust maker control over not only what happens upon their death, but also what happens if they suffer from an incapacitating disability. By providing for a disability panel in their trust, they will not have to rely solely on a court or a doctor to make such a personal decision. Now, advanced healthcare directives and powers of attorney supplement your living trust and can provide direction if you become incapacitated. But if you do not have a disability panel as part of your trust, you're overlooking an important aspect of incapacity planning. The people on and the rules of your disability panel are completely up to you. Setting these parameters while you're still competent and in control is one more way that you can make your wishes known. Now, it's important to discuss the creation of a disability panel with an attorney who can help you with these practical considerations, such as having a medical professional on board to ensure stronger cooperation from financial institutions. Remember that you can always change the terms of your revocable living trust, including the disability panel. Now, for help drafting or updating your estate plan, please reach out to a qualified estate planning attorney in your area to schedule a meeting with them. I want to thank you for watching. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. So if you want to learn more about estate planning, please like and subscribe to our channel so you can stay informed about current things that are happening in the estate planning world.